Hello, my name's Rachel Okello and I'm a UK-based solicitor specialising in immigration and family law matters. And today it's Sunday, I'm in the office. I've just done a radio show with IRI FM in Jamaica, and it was very interesting because we were talking about specific things which have happened in the UK recently around the effects that UK immigration law has had on people, particularly Jamaican nationals. So we discussed the flight, the deportation flight, as we call them, which is due to take place on the 8th of March 2017. And there was some talk that inquiries had been made with the Jamaican government and that the flight had been pushed back. Coincidentally, as I came into the office, I had a message on my voicemail from somebody who has been handed a ticket, a new prospect, not an existing client. So it's a Sunday. You can see we're getting calls all the time, but from somebody who had been handed a ticket on Thursday, that they would be removed to Jamaica on Wednesday, on the Wednesday flight. And this is somebody who's been in the UK for over 10 years. So there's definitely something going on because we've been contacted by other people who've also been given a ticket for a flight on the 8th of March. So whether there's a commercial flight, which is taking an extraordinary number of foreign nationals to Jamaica, or whether they have actually scheduled a chartered flight to Jamaica is unclear. But what is clear is that there is a mass deportation of Jamaican nationals, which is due to take place on the 8th of March 2017. So what do I want to talk to you about in this video? I want to talk to you about what you can do if you or your family members are going to be affected by this deportation flight on the 8th of March, or any other flight where your family member is going to be forcibly removed from the United Kingdom. And the first thing I want to say is, before you consider challenging a decision, ensure that you have the correct grounds to do so. I'm not suggesting that people should make challenges to Home Office decisions which are clearly unfounded. There are many cases where people allow themselves to be forcibly removed from the United Kingdom, where the real issue is that they should leave the United Kingdom and make an application from abroad to come back in. The application cannot be made in the United Kingdom, and therefore the Home Office will deport you, even if it's just because you won't make an application from abroad. So you have to ensure that you've got grounds. Typically, unless you have children or a very strong family life case as to why you shouldn't be removed from the United Kingdom, an application is unlikely to be successful. Because before the Home Office issue you with a ticket, you may have made several applications for leave to remain. You may even have gone to a court, the first tier tribunal, the second hearing in a first tier tribunal, and even an upper tribunal, and it may well have gone to a judicial review. So you are unlikely to be surprised if you've been handed a ticket, but you can still challenge the decision even at this late stage. But I would impress upon you that you should only challenge a decision if you've got grounds to do so. We're solicitors, we specialise in immigration matters, we specialise in deportation cases. We've successfully fought deportation cases, and we are here for you if you wish us to get involved in your case. The second thing I want you to be sure of, and particularly if you're detained, is that you're able to get the correct evidence to support the application. So at this point, you will need family members or friends who are outside of the detention centre to get the correct evidence for you to support your challenge to the Home Office attempt to deport you. And I say this because a lot of the time people say, well, they can't deport me because this, and they can't deport me because of that, because I'll be destitute, because I've got children, because I've got an ill mother in the UK. The Home Office and neither the courts will believe you unless you provide the evidence. And if your flight is imminent, you must provide the evidence to the Home Office. And if you're going to upgrade, if you like, your challenge to the court, to the tribunal, the judge will want to see the evidence. So you have to ensure that you have the correct evidence to support the grounds that you're challenging the Home Office on. Okay? The next thing you've got to do is to be prepared to apply for an injunction. because sometimes people can say they had an application in the Home Office or they had a challenge in the tribunal and the Home Office still removed them. But if you only apply to challenge the tribunal, the Home Office decision in the tribunal, and you don't actually apply for an injunction, the challenge in the tribunal will continue, but you won't be in the United Kingdom. So you need to apply to challenge the Home Office decision and to get an injunction to stop the flight from happening. Well, the flight may well happen, but to ensure that you're not on that flight. And the courts may or may not give you the injunction. They may say, well, this is a challenge that you can make from Jamaica. But if you've got strong grounds, then it's highly likely that the courts will authorise the injunction, preventing the Home Office from removing you, whilst your challenge, your judicial review, most likely is continuing in the United Kingdom. And then once the flight is gone, you can then apply for bail because your removal is no longer imminent. So you can then apply for bail because you've got an application pending in the courts. And if you do succeed in getting an injunction, the next thing that you need to do is ensure that everybody who is involved in your removal is aware that you have an injunction. So if possible, the person who is going to be removed, the details of the injunction need to be faxed to them in the detention centre. They have a facility to obtain faxes. So the injunction, if you can get it, because it may be very late in the day and it hasn't even been drawn up by the courts, but at the very least you should, if you have it, fax it to the person who's in detention. You need to fax it to the Home Office at the airport. So don't send it to the Home Office address in Croydon, for example. Send it to the Home Office at the airport and follow it up with confirmation that they have received the fax and they are stopping their enforcement action. Okay, so if you're under threat of being removed, you can challenge the Home Office decision using the correct strong grounds. You must get the evidence to support those strong grounds. You can then apply to the court for your challenge to be heard, along with an injunction to stop the flight, stop the Home Office from putting you on the flight. And then you must, if you get the injunction, you must let everybody who's involved in removing you from the United Kingdom, make everybody aware that you have an injunction preventing your removal. Okay, and once the flight is taken off, is gone without you, you can then apply for bail to be released from immigration detention. Okay, so that's my tip for today. And you can certainly contact us at our offices on 0121 448 9255. You can follow us on Facebook. We're at Rogals, ROGOLS, and we put lots of information there. So by all means, follow us there. Or equally, you can go across and follow us on Twitter at Rogals, or you can visit us on our website, which is www.rogols.co.uk. So have a good Sunday and keep the good fight going. Thank you. Bye-bye.